In the previous section, we examined the importance of legal standing in probate property sales, emphasizing that only a court-appointed personal representative, authorized through letters testamentary or letters of administration, may list or sell estate property. This section builds upon that foundation by explaining why certain properties must go through probate court in the first place. Understanding the causes of probate not only helps real estate professionals navigate estate transactions responsibly, but also assists clients in recognizing how ownership structure, title wording, and estate planning decisions directly affect whether probate will be required. What is probate and why it exists? Probate is the legal process that ensures a deceased person's assets are distributed according to law or the terms of their will. The probate court's role is to authenticate the decedent's will, if one exists, appoint a personal representative, settle outstanding debts and taxes, and transfer legal ownership of assets to heirs or beneficiaries. In Arizona, probate is governed by Title 14 of the Arizona Revised Statutes, ARS, Paragraph 14, 3101 at SEQ. Probate becomes necessary when a property is titled solely in the name of the deceased, and there is no mechanism, such as a survivorship right, beneficiary deed, or trust, to automatically transfer ownership. When this happens, the title is considered frozen at the time of death. Only a probate court can legally unfreeze it, allowing the new owner to be established and recorded. Common causes that require probate in real estate: sole ownership without a beneficiary or survivorship designation. The most common reason real estate must go through probate is when the property was owned solely by the decedent, without any co-owner or survivorship provision. For instance, if Alice owned her Phoenix home in her name only and passes away without a beneficiary deed or living trust, no one automatically inherits the property. The probate court must intervene to determine rightful ownership and authorize a personal representative to convey title to the heirs. This scenario often surprises families who assume that their inheritance will transfer easily. But under Arizona law, title cannot legally change hands until the court formally transfers ownership. Failure to record a beneficiary deed. Under ARS, Paragraph 33-405, a properly executed and recorded beneficiary deed allows title to pass automatically upon death. However, if the deed was signed but never recorded before death, it is legally invalid. In such cases, the property remains part of the decedent's estate and must be probated. For example, if Ben executed a beneficiary deed naming his daughter as beneficiary, but forgot to record it with the county recorder, the deed has no legal effect, and probate becomes necessary to transfer ownership. Property held as tenancy in common. In a tenancy in common, each owner holds a distinct and transferable share of the property, which becomes part of their estate upon death. Unlike joint tenancy with right of survivorship, there is no automatic transfer to the surviving owner. Therefore, when one tenant in common dies, their ownership interest must be probated, unless it was previously placed into a trust or assigned through another estate planning method. For example, two business partners, David and Carla, own an office building in Tempe as tenants in common, each holding a 50% interest. If David dies, his share must pass through probate to his heirs or designated beneficiaries, while Carla continues to own her half. Absence of a valid will or estate plan. Intestate death. When an individual dies intestate, without a valid will, the probate court must determine how their property will be distributed under Arizona's intestate succession laws. ARS, Paragraph 14-2102 et seq. The court appoints a personal representative and divides the estate among heirs according to statutory priority. In these cases, even small estates may require probate if the real property was titled solely in the decedent's name. For instance, if Robert passes away without a will, leaving behind a home in Mesa and no joint owners or beneficiary deeds, the court will apply Arizona's intestacy statutes to distribute the property among his surviving spouse and children. Ownership conflicts or title defects. Probate may also be required when there is uncertainty about ownership, competing claims among heirs, or defects in title. Examples include unclear property boundaries, unrecorded deeds, or errors in title vesting. Probate allows the court to resolve disputes, establish clear title, and direct conveyance to the rightful owner. In Re Estate of Rodriguez, 2016, the Arizona Court of Appeals confirmed that probate jurisdiction extends to real estate title disputes when ownership is unclear after a decedent's death. This ruling emphasized the probate court's essential role in clearing title issues tied to an estate. Property owned by an out-of-state decedent. Ancillary probate. If an individual domiciled outside of Arizona owns property within the state, that property must undergo ancillary probate in Arizona. Even if probate proceedings are underway in another state, Arizona law requires a separate process to transfer local property. This ensures compliance with ARS. Paragraph 14.4204, which governs foreign personal representatives managing property within the state. For example, a California resident who owns a cabin in Flagstaff must have that property probated through an Arizona court upon their death, unless it was transferred through a trust or beneficiary deed. Avoiding probate through ownership planning. The need for probate can often be avoided through careful estate planning. Ownership forms like community property with right of survivorship, joint tenancy with right of survivorship, and beneficiary deeds transfer ownership automatically upon death. Additionally, placing property into a revocable living trust removes it from the probate estate entirely. Real estate professionals, while not permitted to provide legal advice, should understand these concepts to help clients make informed ownership decisions and to identify when to refer them to qualified estate attorneys. Practical example. Consider Carol, a single homeowner in Glendale, who owns her home in her name only and passes away unexpectedly without a will. Her adult children assume they can sell the home immediately, but discover that title remains in Carol's name. The escrow officer explains that a probate proceeding must occur before the home can be listed or sold. Once the court appoints a personal representative and issues letters testamentary, the representative can act on behalf of the estate to complete the transaction. This example demonstrates that, regardless of familial agreement, probate is a matter of legal authority, not personal intent, and only the court can authorize transfers of sole ownership property after death. Discussion. Why does property owned solely in the decedent's name require probate? Answer. Because title cannot legally transfer without court authorization, and no survivorship or beneficiary mechanism exists to automatically vest ownership in another person. What happens if a beneficiary deed is signed but not recorded before the owner's death? Answer. The deed is void, and the property becomes part of the probate estate. Why does property held as tenancy in common often require probate? Answer. Because each co-owner's share becomes part of their individual estate and does not transfer automatically to surviving co-owners. Review summary. Probate becomes necessary when property lacks a legal mechanism for automatic transfer upon death. Common causes include sole ownership without a beneficiary, failure to record a beneficiary deed, tenancy in common ownership, death without a will, title disputes, or out-of-state ownership requiring ancillary probate. Under ARS, Title 14, probate ensures that estate debts are settled, heirs are identified, and title is lawfully conveyed. By contrast, ownership forms such as community property with right of survivorship, joint tenancy, beneficiary deeds, and trusts can prevent probate entirely. Real estate professionals must understand these distinctions to properly identify when probate is required and when property can be transferred outside of court oversight.